Dear students, welcome to this lecture on forest and wildlife laws. I am Dr. P. Saktivel, working as Associate Professor in the Tamil Nadu Dr. Ambedkar Law University. This lecture, in the first segment, we will be seeing about forest laws, that is about enactments relating to forest and few case laws that are decided by the courts. So, these are Indian Forest Act 1927, Indian Forest Conservation Act 1980, Scheduled Tribes and Other Traditional Forest Dwellers Act 2006. Amongst all, Indian Forest Act is very important for us, so we'll start with that. And before that, we'll have few important facts about India and forest. India is one of the 17 mega diverse countries in the world. That means the number of flora and fauna being counted. And with only around 2.4% of the world's area, that is land area, we have around 7 to 8% of the world's recorded plant and animal species. So we house such a large number of species despite having a very less amount of land with us. So amongst all these 5,150 plant species and 1,837 animal species are endemic to India. Now we'll start with this Forest Act, Indian Forest Act 1927. It has got enacted based on many customary practices we had, and we followed the Forest Act of 1865, which aimed at regulation of forest exploitation, management and preservation of forest resources, and followed by Forest Act of 1878, now which was enacted primarily to control and classify the forest. And finally, we have got into this 1927 Forest Act. This act provides for the preservation of forest and promotion of forest produce and collection of revenues. The second objective is to promote industrial and commercial exploitation of forest. Before which, you may also like to know that forest is one of the primary revenue generator for the British India, especially for timber and other resources. Britishers very much relied on India and other eastern countries. So for them, forest was one of the great revenue generator. Also strategically, it was important for them. So in this context, we understand the historical importance of forest for the British India. And now the Government of India Act, which was to govern the India as a kind of constitution for the British India, provided forest in the provisional list. That means states will have full control over the forest. And several states have made very many policies. Subsequently, we had National Forest Policy in 1952, which was to give local communities to have lesser rights over the national interest, and destruction of forests for roads, irrigation, hydroelectric projects, industries and other projects were justified to some extent in the 1952 National Forest Policy. So, what is the content of Indian Forest Act? It was largely based on previous Indian Forest Act. I mentioned some of them to you. And the preamble of the Indian Forest Act 1927 states that the Act seeks to consolidate the law relating to forest. That means there were many laws prevailing across India in many states for the protection of forest. So it also helped to transit of forest produce across India, and a duty is also levied. And we must also take note that this Forest Act 1927 was a product of British India. This act defines the procedure to be followed for declaring an area called as reserve forest, protected forest and village forest. The act further defines what is a forest offence, what are the acts protected and permitted inside all these kinds of categories of forest. Now, Indian Forest Act, the scheme of the Indian Forest Act provides that it talks about in the preliminary few sections about definitions and reserve forest, village forest, protected forest, the control over forest and lands not being property of the government, and the duty on timber and other forest produce, the control of timber and other forest produce on transit, the collection of drift and standard timber penalties. So these are the scheme of the Forest Act. The Act is a striking and important feature of this Act is that there is no definition for the forest or forest land. In general, we see that in the legal discipline, you will find out some words are not defined. They are purposefully left out because at one point of time or another point of time, you wanted to include few other things that are not defined, or you wanted to keep the definition open. Therefore, the government will have certain flexibility over the term. So that's why many terms are not defined. So here the key term like forest is being not defined is very critical, and it has come to Supreme Court in T.N. Godavarman Thirumalpad versus Union of India. This is an interesting case, so we'll see it in little detail. In 1995, T.N. Godavarman Thirumalpad is actually a old zamindar living in Tamil Nadu and Kerala parts of Nilgiris. So he owned a vast tract of land which comprised forest also. He filed a writ petition in the Supreme Court to protect the Nilgiri forest land from deforestation. Actually, this land was originally with him, under his zamindariship. So now the court considered certain interim directions were necessary because the forest need to be protected urgently. So certain interim directions were given. Apart from that, the court has considered this subject to a larger extent. That means it considered the case for the whole of India, and it found out that there is no definition for forest in the Forest Act. Therefore, in pursuant of these discussions, the court considered the term forest, and it said that it must be understood according to its dictionary meaning of the term, irrespective of the nature of ownership and classification thereof. So initially you think that only forests are owned only by the government. Now even any kind of tree, club of trees or thing that comes within the definition of forest in the dictionary, under the dictionary, will also be construed as forest. So according to this broader definition, any forest defined regardless of ownership, that the state governments or no other authority may allow the use of any forest land for any non-forestry purpose, and non-forestry purpose is also defined. Now the court has given many directions to the state governments and the central government in this regard, regarding the maintenance of forest and cutting the timber, transportation of it and management of it. So the felling of trees in all forests to remain suspended except in accordance with the working plan approved by the central government. And also the court has completely banned the movement of cut trees and timber from any northeastern states, and government departments directed to minimize or replace the use of wood, including military. Military was also requested not to, or to minimize the use of wood. A high power committee was also constituted to oversee the implementation of this judgment and to guide the court in making further orders. And licenses were given to all wood-based industries, and they were all suspended, or they were asked to revise the licenses that were given. Now an action plan was also prepared by the principal chief conservator, shall be prepared by the principal chief conservator of forest for intensive patrolling and other necessary protective measures to be undertaken. This judgment was also criticized to a larger extent for the unnecessary, it was thought by many as this is an unnecessary intervention of the court. Now we will get into the Act. Section 2(4) of the Forest Act provides what is forest produce, and it includes timber, you see timber, and when they are found trees, flowers, fruits and all other parts, and plants, wild animals and skins of them, peat, surface oil, rock and minerals, all of them are considered as part of the forest produce. This is a scheme of the division of forest under the Act. We have given it under the governance structure, as well as the rights and responsibilities of people who are associated with this kind of reserved or village or protected forest. So now reserve forest is the highest protected forest, or it has got the highest restrictions amongst all the forest, and they are all declared by the forest, and government has got complete rights over the reserve forest. You see that here. And then village forest are one of the least regulated forests, whereas the state government may assign to village or any community, and protected forest would stand in between, and the state government may impose any restriction that is already imposed on the reserve forest, and certain rights may be granted to people also. In case of private forest, it is also one of the less regulated or least regulated thing. The government may regulate or prohibit certain activities in the private forest also. This first we will see the reserve forest. The most restricted categories is reserve forest, and these forests may be constituted by the state government or any forest land or wasteland which is the property of the government or on which the government has proprietary rights. Now this further, where forest land or wasteland is the property of the government, the forest settlement officer shall proceed to determine subordinate rights in the land before a final notification is issued for making the area as reserve forest. So in reserve forest, most uses of local people are prohibited. By local people are prohibited unless specifically allowed by a forest officer in the course of settlement. So what are the acts prohibited in the reserve forest? Cleaning of forests for shifting cultivation. I'll explain what is shifting cultivation. Setting fire, and then trespassing. Trespassing is entering into one's place without authorization. Felling of any tree. So these are the acts prohibited in the reserve forest. And quarrying stone, burns or clearing or break off of any land, and in contravention of any rules made in this behalf by state government, hunts, shoots, fishes, poisons water, then all such activities are prohibited. And now we'll get into protected forest. The protected forest is the state where the state government is empowered to constitute any land other than the reserve forest as protected forest, because reserve forests are already protected. So under this protected forest title, the government retains the power to issue rules regarding the use of such forests, but in the absence of such rules, most practices are allowed. Among other powers, the state retains the power to reserve the specific tree species in the protected forest. And now we'll commence with something called as village forest. This is the classification, which is village forest, in which the state government may assign to any village community the rights of government to or over any land which has been constituted a reserve forest. The state government may also make rules for regulating the management of such forest. And now we'll get into something very important and which has already been mentioned, that is settlement of rights in a forest. In settlement of rights, the settlement procedures require the forest officer, called the forest settlement officer, to consider the claims of the local inhabitants to certain usage rights, but leave ample discretion for him or her to relocate, revise, or discontinue such practices. So, and after once the settlement procedures are over, it's recorded, no new rights in the notified land may arise after such notification. So in this case, the role of forest settlement officer at the time of prescribing a reserve forest is very important for securing the rights of people in that locality or those who are already living in that place. Now we'll see the Indian Forest Act, which provides the claims that may be given in the protected or in the reserve forest. So first, a forest dweller might lay claim to ownership of land in the reserve forest, for which compensation will be given at a particular point of time. And second, a claim may asserted for rights to pasture or forest produce. So my community, my village, my personal self has got the right over that forest to go graze or use it for my livestock and so on. So these rights may be there. Finally, special provisions apply to the practice of shifting cultivation, which the forest settlement officer may prohibit without any compensation. So the first two things are very clear. That is, a forest dweller might have a claim over the land, property rights over a claim over the land, forest land. In the second case, it is very clear that a claim in relation to livestock rearing or grazing may be there. So these rights will be settled. Now, what is this shifting cultivation? Shifting cultivation is an agriculture system in which plots of land are cultivated temporarily, then abandoned. And how do you cultivate and abandon and then again cultivate? So you clear the land through fire. They clear the land through fire. Thereafter, once the land is cleared, they do cultivation, and then it is again left for vegetation to freely grow, and then the cultivator will move to the another plot. So this shifting cultivation is very much prevalent in northeastern parts of India, and now there are very strict regulations for it, whereas the rights of people over the land, the shifting cultivated land, is also under discussion, and the government is thinking about providing certain rights to them. Now we'll move to the next important act, an Indian Forest Conservation Act 1980, which was enacted to check further deforestation and conserve forests to provide for matters connected. And the act was made uh, with twin objectives. One is restricting the use of forest land for non-forest purposes and preventing the de-reservation of forests that have been reserved under the Indian Forest Act. So the first thing is, there were many allegations as to use of forest land for non-forest purposes, which is not good for the protected forest, or for that matter any forest. And then second thing is, there was something called as de-reservation of forest. The forest is reserved, but for the state governments or any authority, they go for de-reservation of forest. That means the forest may be cleared, it may be used for cultivation or mining or any other use. Such practices were also prevalent. So in order to curtail all those kind of practices, this enactment was brought in. And also there is one significant aspect of this legislation is, it has given more powers to the union government. So in 1989, the act was further amended to include two more provisions, where it sought to restrict the leasing of forest land to private individuals, authorities, corporations not owned by the government. And now we also see one more important legislation here, that is Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act. Shortly and popularly, this act is called as Forest Rights Act 2006. This act recognizes the rights of forest dwelling scheduled tribes and other traditional forest dwellers over the forest areas inhabited by them. This act encompasses the rights of self-cultivation and habitation, which are usually regarded as individual rights. And the act also deals about community rights such as grazing, fishing, and access to water bodies in forest, traditional seasonal resources, access of nomadic and pastoral communities, access to biodiversity, and the community rights over intellectual property rights, traditional knowledge, recognition of traditional customary rights. The Act also provides for right to protect, regenerate, or conserve or manage any community forest resource for sustainable use. So it also provides for the right to reallocation of forest land for developmental purposes to fulfill basic infrastructural needs of the community as such. This act is an example of how NGOs or non-governmental organization to work on bringing a legislation. Also, through this enactment, we understand that non-governmental organizations can play a vital role in securing the rights of the people, especially tribal people in this case. In this segment, we'll see the wildlife and cruelty against animals. So here we have got two important enactments, the Wildlife Protection Act 1972 and the Prevention of Cruelty to Animals Act 1960. So we'll start with the Wildlife Act, which starts with the constitution of Wildlife Advisory Board. That is an advisory board constituted under this act, which has got minister in charge of forest, MLA, secretaries to the government and forest departments, and chief wildlife warden, forest officers, around 5 members, and other interested persons, around 10. So these are the members of the board. What do they do? What are the duties of the board? They primarily advise the state government, and in relation to the selection of areas to be declared as sanctuaries, national parks, and closed areas, and the administration in general. And they help in formulation of policy for the protection and conservation of wildlife and specified plants. And they also advise in relation to measures to be taken for harmonizing the needs of tribals and other dwellers of the forest. And now we'll move on to hunting of wild animals. Section 9 of the Act prohibits hunting of wild animals which are specified in schedule. So, which are the wild animals are being mentioned in the schedule. There is an annexure to the Act which is called as schedule. So, Section 11 says hunting of wild animals to be permitted in certain cases. What are the cases? One is if an animal is dangerous to human life or is so disabled or deceased, the animal is disabled or deceased beyond recovery, then by order in writing and stating the reasons therefore, permit any person to hunt such animal or cause animal to be hunted. So, and then the killing or wounding in good faith of any wild animal in defense of oneself or of any other person shall not be an offense, which means if a tiger is attacking you, you can kill the tiger just to protect yourself or to protect your neighbor. But you cannot kill a tiger which is in zoo or some other purpose. So only if the animal is endangering your life or the life of a person who is nearer to you, then the animal can be killed, or it can be prevented to that extent. And any wild animal killed or wounded in defense of any person shall be government property. If such animal is being killed, even if you kill the animal is being the property of the government. And under certain special circumstances, permission to hunt may be allowed. That is education, research. So these are the primary purposes for which hunting may be allowed with a limited purpose. And collection of specimens for recognized zoo also may be permitted. And derivation, collection or preparation of snake venom for the manufacturing of life-saving drugs. So for saving the life of others due to snake bite, we prepare medicine out of collection or preparation of snake venom. So for that purpose, snake venom may be collected. And an interesting case between state of Bihar and Murar Ali Khan, the definition of hunting under the Wildlife Protection Act is discussed, and they said it is quite comprehensive. So it not only covers capturing, killing, poisoning, snaring, trapping of wild animal, but also includes every attempt to do so. That means whether you have successfully captured or not, an attempt itself will be amounting to a criminal wrong. So hunting also includes driving any wild animal for the above said purposes. So injuring or destroying or taking any part of the body of such wild animal, or in the case of wild bird or reptile, damaging the egg of such bird or reptile, or even disturbing the eggs or nest of such birds or reptiles would also amount to hunting under wrong under this legislation. That is what the court has held in State of Bihar versus Murat Ali Khan. And the act also talks about protection of specified plants, so which is discussed in section 17A. It talks about prohibition of picking, uprooting, etc. of specified plants. So no person shall willfully pick, uproot the scheduled plants. And grant of permit for special purposes, as we have seen in the case of animals, with the similar purposes for the purpose of education, scientific research, collection, and also for preservation and display, the specified plants may be collected. And cultivation and dealing in these plants may be restricted by the government. And if such plants are found out, they are the property of the government. And the act also deals about sanctuaries, national parks, and closed areas under this law. So section 18 talks about declaration of a sanctuary, and which is done by the state government. And also sanctuaries in reserve forests and territorial waters should be done with the concurrence of the central government. Territorial waters are part of the sea. So 12 nautical miles from the coastal zone is generally called as territorial waters in the sea. What are the restrictions placed on sanctuaries? There are entry restrictions. Permits only can be granted for investigation or study of wildlife and purposes ancillary or incidental thereto, such as photography, scientific research, or tourism. And destruction, damage, removal of animals in a sanctuary is prohibited. Causing fire is prohibited. Prohibition of entry into sanctuary with a weapon, and ban on use of injurious substances all are prohibited or restricted. And control of sanctuaries. The chief wildlife warden shall be the authority, and he shall control, manage, and maintain all sanctuaries, and for that purpose within the limit of any sanctuary, he or she shall take such steps as will ensure the security of wild animals in the sanctuary, and the authority may take other steps also in the interest of wildlife. And now we'll move on to national parks. State can declare an area as national park under section 35, and whatever already we discussed under 26A also shall apply here. And all rights in respects of lands proposed to be included in the national park have become vested in the government. No alteration of boundaries except by the approval of the state legislature to be done. Grazing is not permitted in these areas. Other restrictions already given under section 27 to 30 also applies here. And there is this called as closed area, which is one of the very restricted forest wildlife protected area, whereas no hunting or any wild animal shall be permitted in a closed area during the specified period. And power of the central government to declare areas as sanctuaries or national park is also mentioned in section 38 of the act. And further, section 38A talks about the constitution of central authority. As there was a state authority, there was a central authority. The central government shall constitute a body to be known as Central Zoo Authority. This authority shall perform the following functions. What are they? They specify the minimum standards for housing, upkeep and veterinary care for the animals kept in zoo, evaluate and assess the functioning of zoos, recognize or de-recognize zoo, identify endangered species, coordinate the acquisition, exchange and loaning of animals, ensure maintenance of stud books, coordinate research. These are the powers of the authority. Now, trade or commerce in wild animals, animal articles and trophies are restricted and prohibited. How? Under section 35, wild animal to be government property. All hunted and dead animals shall be property of the central government. Dealing in trophy and animal articles without license is prohibited. And section 65 talks about the rights of scheduled tribes, the prevention of cruelty to animals act, which is also part of protecting the animals. So we'll see that briefly. Section 3 provides duties of persons having in charge of animals. So it says that it shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animals. Whereas in Tamil Nadu, the Jallikattu is being exempted under this act, and section 3 subclass 2, which has been added through a state amendment, says that notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations as may be framed by state government shall be permitted. And there is an establishment of Animal Welfare Board of India under this enactment. In section 5, it talks about the constitution of the Animal Welfare Board. The Animal Welfare Board shall have the following functions. One is to keep the law in force, to advise the central government, to advise the government on improvements in the design of vehicles that are used for transportation, to advise the government or any local authority or the other person in case of design of slaughterhouses, and to encourage by the grant of financial assistance or otherwise where animals and birds may find a shelter when they have become old and useless, and to cooperate with and coordinate the work of associations or bodies established for the purpose of preventing unnecessary pain or suffering to animals, and also to give financial and other assistance to people who are working for animal welfare, and also to impart education in relation to humane treatment of animals and to encourage the formation of public opinion against the infliction of unnecessary pain or suffering to animals. Now, what is cruelty to animals? Cruelty to animal means someone is beating, kicking, overriding, overdrives, overloads, tortures. All these are mentioned in section 11. And if anybody is employing in any work or labor or for any purpose any animal which is unfit to be employed, or if he is the owner, if he is doing so, they are all considered to be cruelty to animals. If someone is willfully and unreasonably administers any injurious drug, that is also considered to be cruelty to animal. So anybody conveys or carries, whether in open or any vehicle or not, such thing is also considered as cruelty to animal. Whereas Jallikattu will not be considered as cruelty to animal because it is exempted by the state amendment. And whoever is keeping or confines any animal in any cage or other receptacle, then that and also if someone is keeping an animal for an unreasonable period of time or chaining it for an unreasonable period of time, and if someone is being the owner neglects to exercise or caught to be exercised reasonably any dog habitually chained up or kept in close confinement, that is also considered to be cruelty to animals. And being the owner of any animal, if someone is failed to provide such animal with sufficient food, drink or shelter without reasonable cause, even if she is abandoning, that is also considered to be cruelty. And then performing animals. The Act also talks about performing animals, that is zoo and other places, and used for training and other purposes. So no person shall exhibit or train any performing animal unless he is registered. And the central government shall specify an animal which shall not be exhibited or trained as a performing animal. As we said, does not apply to Jallikattu as per the amendment. The training of animals for bona fide military or police purpose or the exhibition of any animals so trained is permitted, and any animal kept in any zoological garden or by any society or association which has for its principal object the exhibition of animals for educational or scientific purposes. And in an important case, Ajanta Circus versus the Union of India, if the government declares an animal to be protected, and in such case it is a duty of the government to release the animal from the circus and to give compensation as long as the animal is kept in the custody of the owners of the circus. So that it is a duty of the state, or the court also held that it is a duty of the state to take care of rescued animals. And in this Nasrullah versus state, an important case in the case of in relation to the protection of animals, the main contention was that the owner of the transported cows, around 24 cows, in one lorry in an inhuman condition. And there was a specific allegation that the cows were transported for slaughtering, and out of these 24 cows, one cow was pregnant. And the court found that the petitioner was wrong in transporting in such a way, and the court refused to return the animals to them. Therefore, the court has held that this is the fittest case where the court has come to the rescue of animals and to prevent the cruelty meted out to the poor animals. And the watchful thing of society which are taking care of the animals should be encouraged to stop these kind of offences. In this segment, we have discussed about the forest laws and its history. We also discussed about wildlife laws, cruelty against animals, and their importance. So these laws are vital for our understanding as to working of NGOs in forest, wildlife, and for the protection of the humanity as such. Thank you very much for listening to this lecture. Thank you.